Hi, and welcome to Context, a special edition in light of the historic hearings before the Supreme Court of the United States on May 11th involving the President of the United States, the legislative branch, and the state of New York. So let's just assume we're all on the same page that separation of powers is a critical function of our United States democracy. We have three branches that were designed from the get-go to check and balance each other. That's the basic premise that all constitutional scholars, including the Supreme Court justices who will be hearing these cases tomorrow, work from. So even though the hearings that will be taking place on May 11th will get spun for political points, the hearings themselves are covering fascinating legal doctrine that actually are not political at all. In fact, the Supreme Court does not like to wade in on political questions at all. But the questions they are being presented with are more bricks in the wall of the democracy we're refining based on the culture that we have and in pursuit of the country that we want. So the issues are the degree to which each branch can check and balance each other, and the degree to which a state can impose upon the executive branch, and specifically the president. So the hearings taking place on May 11th are historic in that we've got what I will call a pumped-up question about executive branch freedoms. The President Trump's lawyers have so far argued that a president's immunity from lawsuits while he's in office is absolute, and it bars him from being charged with a crime or investigated while he is president of the United States. Obviously, this brings up the now famous issues about whether a president can stand in the middle of Fifth Avenue and shoot someone and be able to stay in office or avoid investigation. So a big note to consider about the three cases that are being heard is that in all three cases, each of the plaintiffs are trying to subpoena third parties. They're not actually asking Trump for anything. They're either seeking information from an accountant. Another case, they're seeking information from a bank that Trump did business with. Both parties have private financial information that belongs to Trump, and this is a question of whether Congress, who is attempting to subpoena some of these financial records, and in another case, the state of New York, can subpoena a third party as well. So unlike in U.S. v. Nixon, where Congress was attempting to subpoena information directly from the president, these cases are addressing a different tangential aspect of executive power, and they will result in establishing the reach or the lack of reach a sitting president can command on his personal records while he's in office. So there will be multiple cases, a total of 3, that will be heard tomorrow that involve President Trump. And they break down to 2 specific issues having to do with executive branch powers. One is what the legislative branch can do to investigate and impose on the executive branch. That's ultimately the umbrella issue that congressional case raises. And a second case, or there are a few more, but the other issue about the degree to which a president can be investigated by a sovereign state. In this case, the state of New York, and it's the Attorney General of New York who's bringing this matter before the Supreme Court. So this is a good point for me to pause and just remind you that, we live in a nation that runs off of dual federalism. So we've got the federal government that has specific powers articulated in the Constitution. And then also articulated in the Constitution are the states themselves that have even broader powers. But in the Constitution, the state government has sacrosanct rights to run all aspects of governance within its sovereign boundaries, its metes and bounds, as does the United States federal government with its metes and bounds. So dual federalism ultimately presents a direct conflict between states and federal government that we rarely see play out at the Supreme Court level. The case between the states' rights and the executive branch at the federal level is so critical because it will impact the question that burdens the dual federalism approach more than many questions that arise and actually get heard before the Supreme Court, as it directly puts the federal executive branch, the presidency, in the headlights of what has been unquestioned as a constitutional right of the state, which is the police powers within their boundaries. If the Supreme Court justices decide that President Trump's immunity prevents investigation by a state in the policing of matters that happened within their boundaries, that will be a significant precedential erosion of state sovereignty and will have a significant impact moving forward on the relationship between states and the federal government. The other cases raise the conflict between Congress's rights to investigate the executive branch, going back to that old language of checking and balancing. This, too, however, is going to be a significant precedent that could further restrict congressional checking of executive branch behaviors. The law is about precedents. So if Congress is restricted in this case in its ability to subpoena records relating to the president and investigate the president while he's in office, the result places in question the actual power of Congress as the Article I branch, the voice of the people, in relationship to another branch. It will be interesting to see if and how often the justices refer to the voters' chance to vote out a questionable president. They might refer to it as a political question issue. And if that line of questioning takes over, look for an unprecedented diminishing of Congress's powers in deference to the executive branch and under the idea that whomever the people choose to elect, that's ultimately a sacrosanct right that trumps all, for lack of a better word. So that's a bit more about what you'll be hearing on May 11th at the Supreme Court of the United States hearings in the cases in which President Trump is attempting to block a subpoena of his private financial records from third parties. Happy listening, y'all.